Unsiloed podcast is produced by University FM, elevating the stories of your institution.
Welcome to Unsiloed. This is Greg LeBlanc, and I'm here today with Ilya Shapiro, who is a senior fellow and the director of constitutional studies. Is that right? At the Manhattan Institute. Also written a couple books. This most recent book is called Lawless, The Miseducation of America's Elites, which is, it's kind of a, I don't know, it's a polemic, but it's also kind of a memoir of sorts, right? And
of the troubles, as one of my friends coined for my experience with Georgetown. Yes.
Yeah, I mean, I think you have been called the poster boy of cancel culture. I guess that's someone said that, and of course, this is preceded by lots of work studying the Supreme Court, which culminated in a couple books. This one here called Supreme Disorder. I think you have a new edition of this out now.
There's a paperback out that updates. So that book, Supreme Disorder, is about the politics of nominations and the politics of the court more broadly. And the paperback updates it through the confirmation of Ketanji Brown Jackson.
Right. And then there's another book called Religious Liberties for Corporations, which addresses the Hobby Lobby case and some other top cases. So welcome, Ilya.
Yeah. Good to be with you. I'm still trying to figure out what I want to be when I grow up.
Well, I joined the club. But I think, look, this book arose out of a incident which occurred right after you were appointed to a position at Georgetown University. And I think the tweet, I mean, it's kind of crazy that tweets define our positions in today's world, but the tweet was inspired, of course, by the Ketanji Jackson appointment, but you have commented
even before her nomination. It was inspired by the initial response to Justice Breyer's retirement announcement.
Right. But it was inspired also by, a long history of studying the Supreme Court and Supreme Court appointments. And in the book, Supreme Disorder, hopefully we can talk about this. You point out that these nominations, it's not like they only became political recently. This goes all the way back to the founding, right?
George Washington had a Supreme Court nominee rejected by the Senate for political reasons. Yeah, it's not that all of a sudden, starting with wherever you want to put the finger of the modern era, Roe v. Wade or the Robert Bork confirmation process, or Bush v. Gore in 2000, wherever you want to think that, the modern contentious period began, Trump's election, what have you. No, politics has always been a part of the judicial nomination process. It's worked differently, obviously. Under George Washington, we didn't have a two-party system. And then later we had, battles over the Bank of the United States and the Civil War and slavery. Obviously, we had the, very, very contentious period. So it worked in different ways with different factions, trying to satisfy factions within your party, eventually outside interest groups. The real politics, this was Teddy Roosevelt's innovation. I don't care if you're a Republican or Democrat, you just need to be progressive and antitrust in various ways. And then eventually, where I posit in that book, The Modern Era began as really 1968, where judicial philosophies began to crystallize in various ways and definitely separate as between what we know now as originalism, reading constitutional provisions based on their original public meaning, versus kind of a living constitutionalism or pragmatism, where the meaning of the provisions evolves with society. And so what our modern battles are really a reflection of where the culmination of several political trends where divergent interpretive theories map onto political parties that themselves are more ideologically sorted and polarized than they've been since at least the Civil War.
Yeah, I think it highlights this contrast between the way people within the legal academy tend to think about the law and people outside of the legal academy. People outside of the legal academy, they focus on outcomes, right, and the impact of judicial opinions. People inside the legal world, at least there are some people in the legal world who like to think that there is a legal way of thinking and reasoning, which does not prioritize the outcome, but sometimes results in outcomes that you might not like.
Well, you would hope that law and policy are different things.
Yeah.
Because there's a reason why we separate out the judicial power, and that reason is for it to be a counter-majoritarian check. You don't need judges to buttress popular opinions. You need judges to protect against abuses of power by elected officials. You need judges to protect individual rights against mob rule. And so it can't be the case that what's right on the law is always going to be what the majority policy views. And for that matter, Gregory, a good question to ask any legal scholar is to give an example of a legal interpretation, constitutional, statutory, what have you, that goes against your policy preferences. And I tell this to law students all the time. If your professor can't come up with anything like that, then that should give you some indication of what's going on.
Well, I mean, this legal way of looking at the world, I mean, some people would say it's kind of endangered by things that are happening within the legal profession and the legal academy. I mean, hasn't it always been sort of under threat? I mean, I think part of the argument of the book Supreme Disorder is that, there's always been forces that have been, trying to encroach on this way of thinking. And then, of course, the critics of this way of thinking say that this has never been anything more than a fiction.
Yeah, I mean, the so-called legal realist school says that, the judicial opinions really are always just gussying up in legal terms the judge's own political views. I'm not so cynical as to believe that. I don't doubt the good faith of judges whose interpretations I disagree with. I just take issue with their interpretations, and that's perfectly appropriate. But this is it's certainly a problem when people see judges as just other political figures, whether Republican, Democrat, conservative, progressive, what have you. And that's why it's so dangerous when judges incorporate criteria other than their best interpretations of the law when they're deciding cases. To give a very high-profile example, when John Roberts, 13 years ago now, decided that the Obamacare individual mandate, the requirement that you buy health insurance, he said that was actually a tax. It was a tax on not buying health insurance and therefore justified under the taxing power. That did not pass the smell test. I mean, those who liked Obamacare as a policy matter celebrated that. Sure, they got to preserve that policy, that major health care reform, but I think it depreciated the integrity of the court because nobody really accepted that was an honest interpretation of the law. It was Roberts kind of using small p politics to say, that's something for the political process. I'm not going to overturn this major law. And I think that exemplifies I think, unfortunately, Roberts' attempt to always extricate the court from political discussions, but thereby implicate it even further by showing the court to be something other than a legal actor.
So it seems like a move like that could either strengthen or weaken the legitimacy of the Supreme Court.
Yeah, I think that's right. I think in this case, it accelerated our coming populist moment in that voters, the Tea Party then, what eventually kind of evolved into the MAGA crowd, said, okay, none of these so-called institutional guardrails are supposed to be there are going to save us. And so we need our own powerful man to counteract their powerful man. And away we went.
Yeah. So what has changed then? I mean, if there's always been politics in judicial appointments, and there's always been politics influencing Supreme Court opinions. I mean, why do we sense that something has changed? I mean, I remember when there were near unanimous votes on Supreme Court justices. I mean, it wasn't that long ago. I think I was alive for some of them, but now it seems like it always just falls on party lines.
What's changed is that the federal government is really powerful, and this. With these radically different interpretive theories, it's a zero-sum game. There only being 9 justices, or also a finite number of lower court judges, because of course this has filtered down to circuit court appointments. And you have this clash of constitutional visions, this clash of how do we do the rule of law? Is it just a perception of what justice is, or is it being faithful to the text, even if that creates some sort of result that you might not want? And so that's irreconcilable. The only way to fix it isn't to give away the very end of my book, Supreme Disorder. It's not to fiddle with the rules of the confirmation process. We have that's rearranging deck chairs on the Titanic, and the Titanic is not the confirmation process. It's the product. It's the fact that Washington is deciding so many important political issues for the entire country, such a large, diverse country, and so many of these issues end up in the courts rather than being decided by Congress. And if it's decided by the bureaucracy, the rules by which we live our daily lives are decided by regulations and bureaucracy rather than duly enacted laws, well, you can't unelect the deputy undersecretary of whatever it is that's harming you. You can only sue them. And so that's why you have every June the Supreme Court deciding so many of the major political controversies in our country. It wasn't supposed to function that way.
So, I mean, is it just because the Congress has sort of punted on a lot of these issues? There sort of takes 2 to tango. I mean, is Congress sort of kind of happy that they don't have to deal with this stuff?
That's exactly right. I mean, the original Madisonian conception, Madison got a couple of things wrong in his brilliant. I have Madison over my shoulder here.
Yeah.
The authors of the Federalist Papers, Madison, Hamilton, and John Jay. Madison was brilliant in very many ways, but there are 2 key things that he failed to anticipate, because you can't, foresee everything for 250 years. One is the rise of political parties, and the other is that the branches would not jealously guard their power. That is, there is this dynamic that you just alluded to, where Congress is more than happy to punt, to give away its powers to the executive branch, because then it doesn't have to be democratically accountable. If Congress passes the Truth, Beauty, and Goodness Act of 2025 with lots of vague things that all sound great, and then the executive branch, the Department of Health and Human Services, the Securities and Exchange Commission, all of these alphabet agencies end up promulgating rules and enforcing them and investigating and all that, which harms somebody, whether you're a land developer, whether you're a farmer, whether you're a drug manufacturer, lots of different people that are affected by these regulations. They go to their congressman and they say, why did you vote for this thing that hurt me? And the congressman says, no, I voted for truth, beauty, and goodness. Your issue is with the Labor Department. Your issue is with, that agency. And they screwed up. I only voted for good things. And that is the dynamic. And so the Supreme Court, again, this is not just a story of this dance between the executive, their bureaucracy, and the Congress. The Supreme Court, the judiciary, has allowed that warping to take place over the course of decades. And in the last few years, the court has started to push back to kind of rejigger that separation of powers, to force Congress to make those actual decisions. There was a case last term, or the previous term that ended last year, where the Supreme Court put an end to what's known as Chevron deference, the idea that judges should defer to agency interpretations of their organic statutes when they claim authority under the Clean Air Act, say, to issue some sort of regulation. And the Supreme Court said, no, we're going to stop doing that. It overturned a 40-year precedent saying that, okay, as long as the agency doesn't do something crazy, in legal speak, arbitrary and capricious, they can do what they want. And the Supreme Court said, no, we're not going to do that. You as judges have to decide what the best interpretation is. And if that interpretation doesn't give authority for the regulation, then you can't do it. So in little steps, other things that lawyers talk about, the major questions doctrine, non-delegation doctrine, these sorts of things. In small steps, the court is trying to force Congress to actually take the decisions, to actually legislate, rather than punting all of those things that affect people's daily lives to the bureaucracy.
Yeah, I mean, it seems kind of puzzling from a public choice perspective, right? Because public choice theory would say that, every branch is trying to maximize its power. And yet you have these cases where Congress kind of punts to the courts, and then of course, there are originalist members of the court who would want to punt stuff back to Congress, right? It's kind of hard to understand. I mean, I'm with Madison. I would never have predicted this.
Well, the kind of second order public choice analysis of that is that the number one thing that congressmen want, and this is perhaps also a warping of incentives in our public life, is to get reelected. And how do you get reelected? It's to not piss off your constituents. More than trying to do something nice for them, it's to kind of go along and get along, and that means the punting, because then you don't get blamed for something bad that happens. You don't take hard votes, as it were, and with the centralization of, now this is getting really into the nuts and bolts, the green eye shade stuff. The centralization of power within Congress into the leadership offices, the Speaker's office, the Senate Majority Leader's office, your backbench, your kind of line member of Congress isn't doing that much, and so their incentive is either just to trumpet the earmarks that they get for their pet projects in their home district, or to appear on cable news. And to use that as a platform to build their own fame in that way without actually legislating. So I think this is explainable by public choice theory, but that incentive structure has changed over the decades.
Well, I mean, if we look at the composition of the judges, I mean, they're kind of evenly balanced between, judges we might call liberal and those we might call conservative, although I'm hesitant to use those political terms because I'm already, speaking the language of the realists. But if it is kind of divided in that way, and yet the pipeline is dramatically skewed in one direction, right? I think you cite some statistics, something to the effect that, 13% of legal academia would be considered, right of center. And
is it that high?
I don't know. I forget the number. You had a whole bunch of different statistics and numbers, and presumably the student body also, either through selection or treatment, is also, mostly left of
the
center.
broader point is that lawyers, and especially those who graduate from elite schools, are definitely skewed to the left. Yes.
So where are these judges going to come from? I mean, does that necessarily mean we're going to have lower quality judges that are on the right because of the, supply chain?
Well, no. I mean, if you're, this is part of what I wrote about in my most recent book, Lawless. If you just look at the so-called elite schools, it's not necessarily the case that someone who's in the middle of their class at Yale or Harvard is automatically better than someone who's towards the top at the University of Alabama or Iowa or Texas, or all of these different places, and indeed but
even the conservative judges and justices are coming primarily from the elite schools, right?
They are. I mean, there's been a nationalization of that. I mean, look, at the end of the day, there's only so many federal judges, right? 9 on the Supreme Court, about 180 circuit judges, another 600 to 700 district judges. So, I mean, there's enough of a pool, of a pipeline of right of center young lawyers to do that, and the Federalist Society has done a good job of cultivating that network and exposing people to different points of view and developing the intellectual and the social capital for doing that. And at the state level, most state Supreme Court judges or state attorney general's offices are populated by people who went to the flagship public law school within that state. With some exceptions for some of the larger states, but so I don't think it's so much a pipeline problem or an issue of affirmative action for conservatives where we're going to be promoting people who aren't as qualified. I don't think that's the case at all. But certainly this does explain some of the overrepresentation or skew to the left among lawyers more broadly in Fortune 500 companies, AmLaw 200 law firms, government bureaucracies. So, on average, the lawyers, and as I said, especially lawyers educated at these elite schools, are going to skew left. Doesn't mean that there's, very few conservatives. It's still, based on the numbers and how many spots you're trying to fill, that's not really an issue. But there has been a perversion of the law, and it's getting even worse because, as I detail in Lawless, the legal academia has been taken over by the illiberal forces. That is, you see these stories where baby boomer kind of classical ACLU card-carrying liberals are scared of their younger students or younger colleagues who are much more activist and don't believe in the objectivity of law, think that institutions are all illegitimate because irrevocably consumed by or formed in racism and sexism and all of these other structural issues. Now, if you don't believe in the legitimacy of the Constitution, not simply that it should be interpreted a different way, if you don't believe in the rule of law because law is cis heteronormative or whatever, if you think that due process and freedom of speech and equal protection are tropes of white supremacy and need to all be torn down and reconfigured according to some new intersectional matrix based on whether people are part of classes that are oppressors or oppressed. I mean, that's a huge issue, and it threatens the liberty, the equality, the prosperity of America.
Well, I mean, I think the book Lawless, it's not really a bemoaning of the left-leaning nature of the legal academy. I mean, because that's been there, forever. And I don't, ex ante, I don't think there's any way you can object to that. I mean, if we're in Nazi Germany and the legal academy is left of center, like that's a good thing, right? I don't have a problem with that. I'm sure you don't have an ex ante problem with that. I think what you're really decrying is sort of the anti-intellectualism of the legal academy and the sort of diminishment of this notion of objectivity, of debate, of a distinct legal way of thinking.
No, that's right. I mean, look, there is a problem with the left-wing bias among faculty and how they discriminate based on viewpoint, based on ideology in hiring. You have to be that much better a scholar to get a job at a law school if you're not progressive. That all is bad, but that's not a new thing. That's, going back decades. And yeah, when I've been speaking about these issues, I always make clear that mine is not just the latest in a decades-long conservative lament about the left-wing faculty bias. And instead, it's this illiberal takeover. And those, as I said, those hippies who took over the faculty lounge in the 60s, the Berkeley free speech movement, would now be seen by these radicals as white supremacists themselves. And that is in a very, anti-intellectual way, because it's identity that matters, it's activism that matters, rather than truth, however you define it, and however we can fight about what that is, and more than education, and more in the law school context, more than training to become a good lawyer. This fundamentally is the failure of law schools in not teaching these young lawyers all of the tools. Originalism is a trope of white supremacy, and so you don't need to learn it. Who cares if half the judiciary and a majority of the Supreme Court thinks that's the proper method for interpreting the Constitution? All of these sorts of things. It's really doing a disservice to our legal system more broadly.
Now, what's driving this? I mean, I think you quote somebody who was pointing their finger at three distinct groups, right? One are the stupid people, one are the grifters, and the third is the invertebrates. Okay, obviously a bit polemical, but
I don't know if I quoted that. I've written a lot. Maybe I forgot that I wrote that. But
no, yeah, I don't think you wrote it. It was someone who was describing your situation and who created your situation. But I mean, what is it? I mean, I'm just astonished by the fact that sometimes the more elite the school is, the less intelligent some of the students and faculty sound, which I mean I'm still having trouble figuring out how that can be the case.
Well, this is part of the problem with admissions offices. It's not just DEI offices that are the problem, or left-wing faculty. There's a thumb on the scale. If you want to blow up the system, if you want to be an activist, Assuming your grades are high enough, you'll get into some of these elite places ahead of someone who just wants to be a law firm partner or who wants to be a prosecutor or kind of a conventional legal role. But really, I think it boils down to three culprits. And I talk about failures in ideology. That's the sexy thing that's gotten a lot of cover, critical race theory, or in the law school context, critical legal studies, which when I was in law school almost 25 years ago now, we had heard of it. It was something from the 80s and early 90s that had been relegated back to some niche corner of a sociology department or something. Well, that came roaring back. Again, this postmodern theory that truth is not objective and law is illegitimate. We need to tear it down and rebuild it according to these other metrics. So that's the failure of ideology. Then the failure of bureaucracy. So we've talked a lot about faculty bias here, but what's remarkable is how much non-teaching staff has exploded, and particularly at so-called elite schools, such that at Stanford, for example, there are 6 times as many non-teaching staff as faculty, about double the number of bureaucrats or educrats as students. The joke is 100 years ago, Yale students came to campus with their own personal butlers. And now we're trying to recreate that experience for them because there's all of these, paper pushing, what in the public sector would be called civil servants, but here it's, educational bureaucrats. And as the great political economist Mansur Olson detailed in the context of governance, the incentives, again, back to public choice of any type of bureaucrat is to justify their authority and expand their power and budgets. And that's what's happened here, especially with these DEI offices, diversity, equity, inclusion, that have grown, especially in the last 10, 12 years, where they create new rules, label charges against people, investigate them, and punish people for this extreme political violations of extreme political correctness. So you have those bureaucracies, and that includes DEI offices, includes admissions offices, as I just mentioned, and other folks who aren't teaching. And then there's a failure of leadership. Because generally, university presidents, law school deans, department chairs, these are not woke radicals or social justice warriors, generally. They are careerist bureaucrats who have succeeded, who have, climbed that greasy pole by being adept at responding to the incentives that they face. And in the modern era, in the last, especially 10, 15 years, that incentive is to placate the illiberal left. And so, in my experience at Georgetown, Dean Bill Traynor, again, is a very good legal historian. I wish he had stayed as a pure academic. It turned out he's a good fundraiser. That's why they've kept him on as dean, but really a profile in cowardice. And so many of these educational leaders are, again, not woke radicals, but spineless cowards. And so that has allowed this illiberal shift, the move from education to activism to come full force.
Yeah, no, I totally understand the argument about the educational bureaucracy, the diversicrats, the educrats, like whatever you want to call them. But I mean, whatever happened to faculty governance? I mean, when I look around my universities and I know some faculty that kind of are aware of some of the problems that are caused by these bureaucrats with their own agendas. But most of them are just either too busy or too focused on other things to be concerned about it. I mean, so has this bureaucracy and its agenda emerged in spite of or because of faculty governance? I mean, what's the role of faculty? I mean, is it just because they're not paying attention, they're asleep at the switch, and then it kind of sneaks up on them, or are these educrats kind of doing what the faculty really want them to do?
There's a parallel here to what we just discussed with respect to the dynamic of Congress punting to the executive branch. You would think that the faculty would jealously guard their power, and they hold it out as, one of the great things about the universities is we scholars actually control everything. If we don't like the dean, we can force the board to get rid of them and all of this sort of thing. But the faculty has been very happy to abdicate its responsibility over the bureaucratic stuff to these full-time bureaucrats. Faculty famously, professors don't want to sit in committee meetings. They don't want to do anything other than what will enhance their own stature. They can do teaching, and a lot of them actually like teaching and take pride in teaching. I don't want to say that they all, hate the teaching, but, they want to be scholars. They want to write their books. They want to go to fancy conferences. They want to talk to each other about their ideas. And again, we can agree, disagree with the ideas. That's a separate issue. But they found this way, because the influx of money from donors, from the public sector, what have you. And it's like, okay, that burden of having to deal with, gosh, we don't want to police, what students are harassing each other or some other dispute, budgets. We don't want to deal with budgets. Let's hire some people to handle all of that. That's below us. We want to think our heady thoughts. And so again, over the years, and it's remarkable, even 50 years ago, back when the movie The Paper Chase came out, that was faculty governance. I mean, the only administrator was like the dean and his secretary. That was it. You had one faculty member in charge of admissions for maybe 2-3 years. Then he passed that on, thank God, they relieved of that burden. And you had they took turns being what effectively now is the dean and associate dean of students, of this, of that, of, all of these positions have become professionalized, bureaucratized. So yeah, I think it would be a huge improvement, even without reforming faculty ideological bias, just to have faculty governance rather than this bureaucratized governance.
Right. So look, while there are some faculty that are intolerant and that are okay with the kind of elimination of debate within the law schools, I mean, this seems to be largely the students that are driving this, and with the encouragement of the administrators. I mean, is that a problem that can be blamed on admissions or on the way in which the students are taught in the law schools?
I think it's the same answer as to our previous discussion. If there were cultures instilled of respect for opposing views, civil discourse, free speech, due process, then then the mob would not be tolerated, would not be able to get away with what it is.
But I mean, do the students come into law schools already with these beliefs, or do they?
Well, sure. I mean, yeah, there are failures in K-12 with the students coming into college, and then there are failures of colleges by the time they get to law schools, which it doesn't excuse law school deans and their structures that they have in place. You can't just throw up your hands and say, well, the kids these days, we can't do anything about it. I mean, they come to us and they're already bad in this way. We just have to manage decline or something. I don't buy that. And I don't buy that because there are counterexamples that are few and far between. But, at the University of Chicago, among the top 5 or 10 schools, that happens to be my law school alma mater, you don't have this kind of cancel culture craziness because the president on down, all the university leaders said, we're simply not going to tolerate this, and we're not in the speech police business, and we're not going to engage in this cancel culture circular firing squad and all of that. You don't like something a professor says or one of your colleagues says, write a blog post, have a protest, but you can't disrupt class about that. There's here are your rights, here are your responsibilities, and we're just going to enforce that. Or the chancellor of Vanderbilt, Daniel Diermeier, won national acclaim for kicking out students that had taken over his office during the Tentifada, the pro Hamas encampments and all that. He's like, look, it's a very low bar. The rules are clear. You cannot do this, but they're enforced, so rarely. But when they are, to mix metaphors, so much of this illiberalism, whether student-driven or bureaucratic, is Potemkin villages guarded by paper tigers. And if someone just stands up to it, they run away to places where it's easier for them to go on with their shenanigans.
I mean, to what extent do you think that the students the majority of the students, I mean, they just want to get their education and they just want to go through and they want to minimize their hassle. And so, they go along with a lot of this just out of, fear and out of peer pressure. And I think
Right.
many of them would be relieved if they were freed from the commissars, their fellow students.
Yeah,
And
most students just want to get their degree, get their credential, get a job, have some fun while they're at it. And that's about it. They are not politically motivated or philosophically motivated. They're just there because they're, especially when we're talking about law schools rather or some other professional school as opposed to college, they're there because this is the next step on their career trajectory, and they're just trying to keep their head down so as not to be caught in the cancellation crossfire. It's fear. And this is how I counsel students is that you don't have to be a martyr. You don't have to stand up and be, an individual, objecting to every injustice you face, but there's strength in numbers. And, again, this calculus that university leaders who are weak, but they're bureaucratic calculators, succumb to, you have to change that calculus. Now, we've seen that somewhat since October 7th and the rise of this particularly ugly anti-Semitism, other kinds of illiberalism and what have you. But donors and alumni are responding, and they are changing the calculus in many places, and now, of course, the federal government as well. But that's what it's going to take to change any place. And some will change, some will not. We'll have varying degrees and types of reform, but it's going to take those kinds of exogenous shocks, because it's not about reasoning with university leadership that here's your free speech policy. This is why you need to enforce it. This is why open inquiry is a good thing. Yeah, you have to make that case, but ultimately. Again, public choice. I didn't think that this podcast would focus so much on public choice theory, but that's how these things are run.
well, look, if that story were true, that most of the students are just, conformist and they're just playing along, then, would there really be any long-term harm? I mean, I remember when I was at Duke, right, during the 90s, when, the dominant discourse in the humanities was one that was filled with critical theory. And I remember everybody would say, even the folks who were supporters of critical theory would say, yeah, these students, they just play along and they fake it and they know how to get along. And then when they go to Goldman, they'll be doing the same thing, getting along. And so, I mean, that cynical view would suggest that, this is not really something that we should worry about. It's like, when people are young and stupid, they do young and stupid things. But I think you're suggesting something different, which is that, this is impacting long term the supply of legal professionals, right? And we see some evidence of that, where young associates come into law firms and they sort of continue to engage in these practices. There's some anecdotes that you tell in the book about law partners that have been sort of chased out of their firms for having views that were unacceptable to their colleagues.
Yeah, it used to be the case, or at least we thought it was the case, that these attitudes would stay on campus. The adjective sophomoric is there for a reason. They just don't know any better, and then once they're exposed to the real world and see how things work and get their first paycheck and see what the taxes are removed and all the rest of it, they'll lose those kind of childish pretensions. But the last decade has taught us that that's just not the case. It's the virus has escaped the campus and it's infected the junior ranks of you hear about it in Hollywood and Netflix and these other kinds of organizations, corporations, but it's perhaps most dangerous in the legal profession, because after all, this is the next generation of gatekeepers of our legal and political institutions. And if the law falls, then, all bets are off for the rest of society. The only thing that's perhaps more dangerous is what's going on in medical schools, where literally, doctors are engaged in a life and death profession. And if whether you live or die depends on your race, good Lord, that's a big problem. Or your gender or whatever, access, under COVID, the access to medicines depended on, your social credit score or whatever the case was, just a bunch of craziness. So yeah, this has gone beyond campus for whatever reason. It began to change reality rather than be changed by reality.
Yeah, I mean, you point out that the professional schools are in many ways different from the rest of the university. I mean, if the English department gets taken over by critical theory. I don't think this would have profound consequences in quite the same way as, say, medicine, engineering, and law. But even above that, I mean, there's something about law where we hold lawyers to higher standards, right? We kind of expect something that's different. It's kind of like the military, right? We don't expect the military to need a crying room or whatever. We don't, and I mean, no, seriously, I mean, it's like we want them to be a different type of person. We want them to behave in different types of way. We don't want them to necessarily reflect the rest of society in terms of their attitudes and character. Is part of this due to, I don't know, a lack of appreciation for the unique role that lawyers play in our society? I mean, historically, lawyers were seen as, for better or worse, right, removed from the rest of the world. They engage in different types of practices. They can be opposed to each other and then go out for drinks afterwards. That's not normally what you see in other parts of the world. They're willing to take on completely different positions depending on who their client is. They're trained in logic and a particular form of communication above others. And it seems like those elements of distinctiveness have kind of dissolved.
I think that's right. That's another failure of our systems of legal education, or of the culture of the legal profession. Young lawyers seeing themselves as the law or their legal tools as just another part of activism, rather than as a profession. Or law schools not teaching lawyers the same way. The way to be a good lawyer is to be able to understand and see all sides of a given argument or issue or dispute. That's how you can best advocate your own sides, your own client's position. Well, if half of that 360 degrees is illegitimate, or you can't even discuss beyond the pale, outside the Overton window, as they say, then you're going to be a much less effective lawyer. And yes, I think the legal profession has suffered in general, its credibility, its reputation. You see that with the decline of the American Bar Association, for example, which, when it was founded for many decades, was kind of the industry group and the elite industry group of the legal profession. And then, its president in the 60s, Lewis Powell, used that as a jumping off point to become Supreme Court justice. But then it became just another left-wing activist group, advocacy group, composed of lawyers in this case. And so just in a few decades, the percentage of lawyers who are members of the ABA has declined precipitously. I mean, now it's somewhere in the middle teens. Whereas, just a number of decades ago, when Lewis Powell was president, it was, 50, 60, 70%. It's unfortunate. And some of us, think about what it might have been like to practice in those days of, mahogany everything and musty law books, and people looked up to lawyers as having some sort of, almost like they were wizards with access to some unique knowledge. And now it's just, well, you're just another form of debased money grubber, at best, grifter. That's not a good thing. But lawyers continue to play a very important role in our society, obviously, whether as judges, prosecutors, counsel to important public and private sector officials. And that's why it's, this perversion of higher education generally is particularly dangerous when it comes to law schools.
Yeah, I think most people are unaware of the role that the ABA plays in driving legal education, right? So the threat of decertification is always real.
They have a monopoly on accreditation. This is, talking about the bureaucracy is unsexy. Talking about accreditation is even less sexy. And that's a huge issue in higher education more broadly, but with law schools and with medical schools, by the way, where the American Medical Association plays that same monopoly role. You cannot be accredited as a law school unless you satisfy the ABA. And it's imposed all of these DEI rules, a whole host of other things that have nothing to do with training young lawyers to uphold the rule of law.
Now, I've had some other podcasts where we talked about the U.S. News ranking system and other ranking systems. And, this seems to play a role in homogenizing the legal academia. I mean, in almost every other aspect of the world, right? We have market segmentation. You have, you have your Toyotas over here and your BMWs over there, and yet all of the law schools seem to be, I don't know, coming from the same playbook, except for, as you mentioned, University of Chicago. I mean, why is that? I mean, why wouldn't it make sense for these different law schools to say, you know what, we're going to be a school that abides by these rules, and another school could differentiate itself and brand itself as abiding by a different set of rules or ideologies? Why don't we see more heterogeneity across these different schools?
Part of that is uniform accreditation standards, and there's no competition. The liberal arts colleges can say, we don't like this accreditor anymore. We're going to go join a different accreditation. So whenever there's competition, you're going to have, I think that's a healthy development, which you don't have with law schools. Another thing is just kind of the nationalization of law. Part of the information revolution is everybody knows what, at the click of a button, can see what Harvard's curriculum is, what Stanford's curriculum is, University of Texas, what have you. There is an attempt at differentiation, not among the top 15 or what have you that are national schools that want to send their graduates to all the top firms anywhere in the country, not just where they are. Lower down, you do see some differentiation. We have this intellectual property clinic. We are, in New Orleans, there's a school that's really good in admiralty law because there's shipping and stuff like that. So you do have a little bit of that, but yeah, there has been kind of a move to uniformity as there's been kind of a nationalization generally. That's also why, by the way, Supreme Court justices or elite lawyers all went to, top number of schools rather than, for example, John Paul Stevens, who was the best lawyer of his generations from Chicago, went to Northwestern. Why would he go to Harvard or Stanford when you have Northwestern right there? Now, I think he still erred by not going to the University of Chicago, but that's a separate discussion. My wife went to Northwestern, I went to Chicago, so we have that conversation. But anyway, there's been a nationalization of information, of the profession, of standards, and that sort of thing. I think U.S. News also has limits. They're competing. Ultimately, I think what you would need to have is different, not accrediting bodies, but certifying bodies. The old, what's known as the housekeeping seal of approval. Now, that was not, an accreditation. You couldn't, make I don't know what it was, a stove without getting that seal. No, but you would compete to get that kind of award, that certificate. And so similarly, you could have certification by, any number of organizations, be they politically oriented of, left, right, or whatever, be they specialists in intellectual property, be they, the tech sector, whatever, we like this law school. These are the law schools that we take our lawyers from. That's really what a good system would be like. And it wouldn't be so monopolized by the ABA or U.S. News on the rankings front or other kind of these dynamics that force uniformity.
Now, look, there's been a lot of pushback in the last couple of years against DEI, particularly from the Trump administration. I should say pushback in the last 6 months. Right? But it seems like the folks who are pushing back against DEI are, borrowing from the DEI playbook, right? Because they're using some of the language. Right? Language of diversity, right? Okay, you want that diversity, we want this diversity, right? And the DEI folks were talking about how everybody should feel safe. And it seems like now we have Congress people saying that, everybody should feel safe, including Jewish students. I mean, is the this new pushback really reflect, I don't know, a return to a view of an idealized view of what the academy should be like, or is it just sort of tools being appropriated by a different side?
So first of all, I'm definitely not for just rejiggering the DEI constellation or the intersectional matrix or whatever, the hierarchy of privilege or all of these sorts of things, or making sure that Jews are included, making sure that conservatives are included, or adding more protected categories. I don't think that's the right way to go. That's not the right way to think about it. So to the extent anybody wants to push different kinds of safe spaces, or again, include Jews as a class that you're not allowed to slander under penalty of hate speech prosecution or something like that. No. On the other hand, it is the purpose of universities to have free inquiry, to have civil debate, to confront new ideas. And if universities have not been doing that for a whole host of reasons, then I think that's a level of criticism and something that they should be held to account for, not in the numerical sense of quotas. We need to make sure that half the people you hire for your physics department are registered Republicans or something like that. I don't even know what, diversity would be on a physics department. Is it different views on quantum mechanics or something? I don't know. Sure, you can joke about that. Well, in the political science department, you can have that. Well, no, not really. I mean, again, just take away any sort of discrimination against people that's just viewpoint based. And is it a proper role of government to enforce those certain things? Maybe some level of government. They're federal dollars. This is the problem. If you have federal dollars, then there's a whole host of strings attached to that, including free speech protections, civil rights protections, and all of that. And so I think it is appropriate to put many of these institutions in receivership, because they've been violating all these rules and regulations and civil rights laws for a long, long time. I don't think, if done properly, that's just using the tools of DEI, but from a different direction. It's not a matter of the federal government taking over universities, but removing funding is perfectly fine. Or for state, it's a different sort of discussion at the state level, where state legislatures properly regulate universities. They can say, we don't need every one of our 15 state universities to have a mechanical engineering department or a poetry department or whatever. Here's how we want to structure our public education system. And we don't need all these bureaucrats as well. So that's a separate rule for the states. We can debate, I think, at the margins what the proper role is: state, federal, private investors or donors or trustees or other kinds of stakeholders. But I do think that reforming our higher education sector, which I think it's badly in need of reform, and that's been thrust into the national discourse since October 7th, and the congressional testimony and all that, it will take external pressures, or what economists would call exogenous shocks.
Well, look, you've given a lot of attention to these speakers that have been canceled, including yourself, right? And when you went to Hastings and tell the story, of course, at Stanford, everybody knows about. But it seems like, that's just the tip of the iceberg, right? Even if you had all of these outside speakers coming in and they were able to do their thing in peace, that wouldn't really solve the problem, because it seems like the real problem is in the classroom, right? And in the faculty lounges, right? Where there is a lot of self-censorship going on. How do we address that?
Well, that relates to the previous question you asked me. How do you ensure viewpoint diversity of thought? And I think here there might be a pipeline issue. Not as many conservatives or libertarians go into academia. But is that because they see the discrimination against them, or is that because they're just not inclined? They're more inclined to go into, business or other things. And it's a complicated question. But I think simply removing the ideological or viewpoint-based discrimination, adopting what Chicago has called the Shills Report. We've heard about the Chicago Statement on Free Speech, the gold standard. That gets a lot of play. Now we've heard more about the Calvin Report, which is institutional neutrality, universities and their subunits not taking positions on public policy issues. The third part of what's sometimes known as the Chicago trifecta, the Shills Report, which is non-discrimination ideologically when hiring faculty. I think that's important. And, we have to get away from this attitude that, some hiring committees say, well, we're not discriminating ideologically. It's just to have that conservative viewpoint on political philosophy means ipso facto that you're a substandard scholar and you can't rigorously evaluate arguments. I mean, I think it's a bad faith position, but it's really, how do you deal with that? Again, is it the threat of loss of federal funds based on that kind of viewpoint discrimination? Ideally, it would be the trustees coming in and hiring the president and the provost that would not tolerate that sort of thing. But it's a complicated way to unwind that, particularly for private institutions.
But it seems like that is not the real issue. I mean, you could have a law school with 50% conservative, 50% liberal, and if they never talk to each other, right,
Sure.
then
Sure.
you'd still have the problem, right?
I mean, I think there's a lot of parallel. A school that is honestly devoted to hiring the best people regardless of ideology, I think is going to have people who are in civil discourse. And, deans have come up to me. I've spoken a lot about these issues over the last several years, before and after my book. And deans have been in the audience. They've come up to me and they say, what should I do? Okay, I get it. Enforce the rules against shutting down speakers. I get it. We do that. We discipline students. Like, this is not acceptable here. But what else? And I say, well, don't rely on just the Federalist Society to bring in speakers with alternative views. Have a Dean's Speaker Series, or even better, a Dean's Debate or Discussion Series, where you have, whether members of faculty or outside speakers, broaching these sometimes politically controversial, sometimes analytically controversial. You kind of have a debate about how to regulate AI, right? Very controversial, but not necessarily politically salient. But that has to be modeled. That sort of culture has to be instilled by university and law school leadership, which is very good at instilling whatever culture they want, whether it be entrepreneurship, public service, social justice, open inquiry, civil discourse. That has to be right up there.
Yeah, but what about the professional norms? I mean, you can model them, I suppose, but I mean, do we need to have more intentional training around professional norms? I mean, I remember certainly when I was in law school, it was a big part of the education, right? Was, understanding that there is a particular way that you need to engage ideas and you need to engage other people. I mean, we have, I think, DEI training for most of our incoming students, but I don't think we have any incoming orientation that discusses what an acceptable way to debate is, right? I mean, do we need to
that
kind of do that more explicitly?
that kind of modeling, that kind of culture of open inquiry and civil discourse, it has to start with orientation, or even before orientation, when you get all those readings over the summer before you matriculate, and the messaging that comes from the dean has to be, if you encounter an idea that you think is uncomfortable or wrong or hateful, we're not going to take that complaint. If you're being harassed, that's one thing, but here's the difference, laying out all of these sorts of things, because deans have to know that the colleges certainly aren't generally giving that kind of acculturation to the students.
Well, it certainly seems easier to nip it in the bud than to deal with it after the fact. I mean, you gave some examples of how, I think it was the University of Chicago, where they actually expelled a couple of students for violating these norms. And of course, at Stanford, I mean, there was no expulsions, and it would be hard to expel a large number, or at Yale to expel a large number of people. So it seems like you have to kind of do it
And
very
just to be clear,
forcefully
some of your
beginning.
listeners might
Yeah.
not be familiar. You're referring to Judge Kyle Duncan, who came to Stanford and was shouted at and said, "We hope your daughters," yelled, "We hope your daughters get raped." And then the dean, the next day or the next week after she apologized to Judge Duncan in a letter, had a silent protest in her classroom. I mean, it was just, again, this is Stanford. This is not some podunk tiddlywink place in the middle of, this is, I think that year tied with Yale for the #1 U.S. News ranked law school, what have you. And these are students that weren't even disagreeing with something that Judge Duncan was saying in his talk. His talk was on relatively nerdy things, but just because he had represented clients or written law review articles in the past that these students were offended by, they thought it was good to yell at them in various ways. that's a failure of leadership. And the rules were there. It's not a failure of public policy. Stanford didn't have policies to deal with this sort of thing. It's just wasn't enforced. And indeed, their DEI dean was there fomenting that particular mob.
Well, and I think another issue you point out is that students, whether you call it safety culture or whatever, it seems like students are incapable of confronting things that they consider to be injustice, right? Whereas to be a lawyer, one needs to have the ability to maintain one's composure and actually try to tackle
This is what
these
I've been
issues.
telling students. You're gonna be confronted with much more challenging issues or dilemmas in your legal careers than a speaker you don't like or find offensive. It's just the level of, I don't know whether you call it intellectual immaturity or what, but it's startling. And when I was in law school, I had classmates who were of the activist bent and disagreed with certain things and wanted to change the world in various ways. They didn't go about shouting down speakers and what have you. They try to write incisive law review articles or invite speakers to make point. I mean, there's, on top of the kind of illiberalism and what this says about the culture and the legal culture, it's just not effective. And again, law schools are failing in teaching their students about what effective legal advocacy is.
So what are some of the reforms that you propose? I mean, there are some in the book. There are some that aren't in the book that we alluded to, right? Some of which might mean more faculty governance over what happens in their schools. But that would only be possible if, the esteem that we give to our colleagues is less dependent on their publications, perhaps, and more dependent on their service to the institution.
Well, I think tenure decisions still include a service requirement. It's not that the failure in faculty governance is a function of over-esteem on publications. In fact, so many publications are useless in and of itself. I mean, that's a separate issue. The architecture of law reviews and or academic journals more broadly. I think it's reducing the bureaucracy, changing the admissions offices, enforcing federal rules against discrimination. This is what the Trump administration is trying to do. I would question some of the strategy, like issuing a demand letter rather than what they've been doing lately, which is concluding investigations and identifying a bill of particulars of where violations have taken place, and thereby demanding changes. I think that is the successful and statutorily provided way to go. Employers have started saying we're just not going to hire people who aren't trained. We can't expose our clients to people who think it's okay to yell at federal judges or support Hamas or something like that.
And some of the judges have changed their clerkship policies, right?
Yes, there's boycotts of Yale and Stanford, prospective, not anyone who's there, but prospectively, they're saying these schools are failing to educate these students in various ways, so we're not going to hire from there. It's a controversial position. I happen to support it, but it'll take these external forces, as I've been saying. State legislatures have gotten involved in saying we're just not going to fund this, the state attorneys generals are enforcing the Supreme Court's ruling in the Harvard affirmative action case, making sure that racial preferences aren't being used. But again, these things are happening differently in different states. So we're having a natural experiment of our students migrating from different states or from private to public. And we're seeing some of that. There was an article, I think 8 months ago now, in the news side of the Wall Street Journal about how applications to Northeastern liberal arts colleges are way down, and applications to Southeastern flagship public universities are way up. Because I called this I think I've coined this. I haven't seen this anywhere else. The problem of the colds and the scolds. Right, you want to get away from the bad, the cancel culture and the climate, the bad ideological and meteorological climate in the Northeast, and go have fun, watch football while getting educated on civics or what have you in SEC schools.
What about the ABA? I mean, is there a way to reform the ABA or replace the ABA, and then also like the the rankings. Is there a way that the ranking system can be kind of hijacked to make it, I don't know, incorporate
Well, I've written
tolerance?
about how the ABA's accreditation monopoly needs to be removed. And there are two actors that are relevant here. One is the Department of Education, which certifies schools for eligibility for federal student loans. And if it didn't require ABA certification for that, that would help. And then state bars, which are generally controlled by state Supreme Courts, which set the rules for who's admitted to practice before them, who's admitted to be bar eligibility, and generally you have to have graduated from an ABA accredited law schools. That should change. Texas and Florida are looking at changing that right now. It's not going to change things overnight. Interestingly, California has long had the biggest tradition of non-ABA accredited law schools where you're allowed to practice in California but nowhere else. Those tend to be not even second tier but third tier law schools. Hopefully, if there's a liberalization and a decoupling from the ABA, you would have more competitive places. And that's tied to the rankings. U.S. News sort of has a legacy advantage in branding, but if people stop caring about that and care more what a consortium of big law firms or certain scholars get together, and people can choose to care about what they want. We want certification by Silicon Valley or the Texas oil and gas industry or whoever, and you can have different things, different sorts of rankings, and whoever's hiring can say, well, I care about these rankings but not those rankings or what have you. But it's not an overnight solution, and it's dynamic and it's market driven, and I think that's ultimately what's going to have to fix the rigidities.
Well, I look forward to seeing what's going to happen in the next couple of years, both in law schools and with the Supreme Court. And I'm sure you'll be writing about both of these things going forward. So thanks so much for joining me. The latest book is called Lawless, The Miseducation of America's Elites. Thanks again.
Thank you, Greg. And I have a Substack called Shapiro's Gavel. So musings that don't necessarily make it into the Wall Street Journal are right there on Shapiro's Gavel.
Check it out.
Unsiloed podcast is produced by University FM, elevating the stories of your institution.